Is there anything in the table in here? I have to bring in a long table. Okay. State of Florida versus George Pino. Parties announced, please.
Good morning, Your Honor. Laura Adams, County Divorce on behalf of the state.
Good morning, Your Honor. On behalf of George Pino, who's present, Howard Srebnick, Edward R. Molina, Mark Shapiro, who's Janelle Gomez, will be here in a moment.
All right.
Thank you.
Well,
Good morning, Your Honor. I do. Thank you.
All right, very well. The jury should be here shortly. Just want to take up and we're going to address the final instructions that were, although we had our charge conference last week, there were additional meetings and discussions via email that the parties have had with the court, and a few additional pleadings filed that I would like to address. And again, I believe we addressed them during the course of the charge conference, but for purposes of the record, I'd like to go over some of these special jury instruction requests. So, defense filed yesterday objections to the June 12, 2026 amendments to the standard jury instructions on manslaughter, and my understanding of this is for the culpable negligence instruction as the misdemeanor under the standard jury instruction 8.9. There was some modification of the language of 8.9, and this modification in the amendment actually now mirrors the language of the felony culpable negligence jury instruction, of which you had last week in the charge conference, requested this court to include additional language in the standard of the felony. You requested that the language of the misdemeanor culpable negligence instruction be included.
Correct.
Okay. So, I'm going to ask the state if they had any comments on it. I mean, I've read the pleadings, I understand the issue and the argument and the basis for the argument that they're making. And again, it was something we addressed, but, excuse me. It was something that we did address. So, let me just ask Ms. Adams, and Mr. Boris, was there anything that you wanted to comment on with regard to, it was the defense request for the, I guess, pre-amendment language of the misdemeanor jury instruction under 8.9 to incorporate that into the standard manslaughter instruction 7.7. All right, I'm sorry, Ms. Adams.
I understand the defense request. I think that we litigated this on Thursday. I think the court has already ruled. I think that the instruction in manslaughter regarding what culpable negligence is appropriate. I think, Your Honor, I haven't had much time to look at the instructions, the final ones that we got from Your Honor.
Okay.
But in reviewing the instruction that the court gives on page 8 of the total packet, when the court defines culpable negligence, I think that it is an accurate statement of the law, and I see no reason to import a misdemeanor into a felony homicide charge.
I think that was, if we kind of break it down and try to simplify it, if we can simplify it, I think that that was the intention of defense, and I don't want to speak, to have the definition of culpable negligence for the misdemeanor added, that language added to. Am I right about that?
Correct, as well as other
There were other
propositions
requests.
of law that we had proposed in the case law, but yes, you're correct.
Okay, so, having reviewed this again, and I did a little additional research, and I am comfortable that the instructions as they exist currently under 7.7, as the current standard instructions for manslaughter 782.07, they are appropriate without the inclusion, because there's a separate, again, jury instruction. 8.9 is the separate jury instruction for misdemeanor culpable negligence in misdemeanor sense. So, which would be a charge under 784.05, which would be the culpable negligence, but as a misdemeanor charge, not as a felony charge. So for those reasons, I am not going to, and I understand also, and we'll get to this when we talk about the reasonable doubt, because everyone I think is agreed on that, but I am going to decline to include additional language to the standard instruction, which would be the former definition of culpable negligence as a misdemeanor. So, for the record, though, your objections and your amendment and the requested special instruction is part of the record. And so that is, we decline from doing that. And then there was the, and I think this goes again to the discussions we had last Thursday during the charge conference on the two different theories under manslaughter for where the jury could come back under either the intentionally committing an act or acts that led to, that caused the death of Lucy Fernandez, or the death of Lucy Fernandez was caused by the culpable negligence of Mr. Pino. Okay, so and I heard all the argument, and I understand the defense position is you submit that the intentional act under that theory is actually the striking of the marker. And I don't know if I think the state has responded on that. I reviewed that. I don't agree after I read additional case law, I don't believe that that is the intentional act. So I was declining to give any additional instruction in that regard. And then you also had requested, though, I see here, to, so that, was there anything else on under 2A?
Yes.
Okay.
So the anomaly that this creates is that intentional is an act that assumes that the operator is intending to essentially crash. That's what it has to be that, otherwise there's no causation to the between the act and the death. And the alternative theory of culpable negligence is assuming just a course of conduct so irresponsible it leads to a collision that was not intended. The state has, from the beginning of this case, said in their traverse, they take the position that they have no reason to believe Mr. Pino intended to crash. So what we're left with is two theories that the state is going to the jury with. One that just start with the culpable negligence, let's just call it irresponsible, indifferent, conscious, all sorts of negligence type.
Culpable negligence.
Without intent. It's not an intent crime. On the other hand, with 2A, what is the act? I would just ask the court, the jury needs to know what's the act they're looking for.
And if you read the case law, my interpretation of the case law, it's the act, and it's defined here. It's not necessary that the state prove that the defendant intended to cause death, but to commit an act that was not merely negligent, justifiable, or excusable, which causes it. For example, let me give you an example of the case that I read. In the vehicular, in the vehicle case, where there was a death. And the theory was under an intentional act. Driver and passenger. Driver and passenger get into a dispute while driver is driving. And passenger reaches for and jerks the wheel of the vehicle and commits an act intentionally, which is the jerking of the wheel, which then ultimately results in the car veering off and hitting a tree and killing the driver of the vehicle. Okay? You can see it the other way around. But my point is the act under those circumstances, and again, this is my interpretation of reading the cases, as to why there are two theories under the manslaughter. The act was the grabbing of the wheel, not the plowing into the tree. So that's the way I'm interpreting, and I didn't ask for this. Stated that we had responses on Thursday, and the state made the responses, but I went back and I did a little more work on that over the weekend. So while I absolutely understand your position on 2A, intentional act, that it creates an odd situation, and it could never be. But that's why there are the higher crimes when a death occurs of second-degree murder and first-degree murder. So that's my understanding. And your argument?
And it sounds like by analogy they were suggesting that the intentional act from 2A is...
I'm not suggesting anything. I'm just giving you my interpretation of why there are two theories as charged by the state here, and two theories under which whether or not the state can sustain their burden under either theory of manslaughter is a different thing.
So for example, in our case, the intentional act, if you do it broadly, operating the motor vessel, just broadly, that Mr. Pino intended to drive or operate the motor vessel. That's so broad, and that the argument is that he intended to drive the motor vessel, and that eventually led to a...
I'm not sure I agree with that.
That shouldn't be the law, right?
Well, I'm not sure I agree with the example you're giving, and I don't want to, what I am not going to do is, I'm not the jury. The state and yourself are going to be closing arguments to explain to the jury what you believe the evidence was and how the jury could apply the law or not apply the law, or even applying the law, the evidence either reaches the element of proof necessary beyond reasonable doubt, or does not. And so the state will argue how it does, and you're going to argue, sure, how it doesn't. So I'm going to leave it at that.
I think it creates a notice problem for us in terms of what was the act we were defending against. We always assume that the act is the elision. Under that problem, that the state was, if it's in the charging document, there's two theories. Either we intended to crash, meaning you can see examples where people bump up against the pylon intentionally, too fast, someone gets hurt, and if it's done intentionally, not merely negligently, then there may be liability. On the other hand, the driver is not intending to intersect or arrive at the marker, but happens to do so because of an erratic driving pattern. That would be another theory, which is the theory we've been defending against since the beginning of this case, because the state had made it clear, particularly in its reverse, they're not claiming he intended to arrive with the marker. So that's what's giving us the concern. We submit that 2A manslaughter should be stricken.
Excise that.
And I think we preserve that issue.
Absolutely.
I'll reinforce it. And then I'll be listening carefully to what the state argues in closing, and be mindful of what Your Honor has said to us about the case law, about the passenger grabbing the wheel, turning it, and that causes the...
Again, that when I read the cases on the different means by which, in a criminal case, elements of either the intentional act of 2A or 2C, the type of evidence, every case is different, right, factually. So that was my interpretation. Okay. Let's get to, I think, the final...
Judge, before we leave that, to make sure you receive our pleading proposing the instruction.
Yes, I'm going to talk about that.
And we filed it, so
Right.
where we propose the instruction on manslaughter 2A.
I see that, and in that proposal as well, you also, then there was an additional pleading where you asked for, under the vessel homicide instruction, you asked that the court provide the jury with the additional special instruction as a vessel homicide, which were case examples with citation to the case, with the factual summaries of the cases.
Yes, Judge, it was both for vessel homicide and for the manslaughter.
Yeah, vessel homicide, you had about 12 examples, I think.
You made it 13.
13, there you go. And for the manslaughter, you had, which were the cases that were presented and we addressed earlier on as well.
In the motion dismissed.
Yes. So I am not going to instruct the jury with case law or summaries of case law, factual summaries of different cases. But again, this is part of the pleadings and part of the record. The other matter, and I think we've all agreed on the navigational rule instruction. If you look at, I gave you all what I call the final instructions. If you look, I did, and thank you for pointing it out, during the charge conference, I agreed that the additional language of individually or cumulatively would be included. And if you look, and I think it's included in the correct place where I had agreed that I would.
Yes, Judge, I see it at page 10 of the paper copies that were delivered to us this morning by your chamber.
Okay. Okay, so that's good. On defendant's statement or statements, because there were various statements, and when the jury is given the opportunity, and as they should, to determine whether or not statements are voluntary, I just included the word statements, and then I put the parentheses S when I said the word statement in the rest of the instruction. Look at it, I'm just
Do you know what page number that would be?
Let's see.
Page 18.
Thank you. Starting on 18. Yeah, it's just one other page. So the first sentence, if you read, I said statement or statements. And then from thereafter, I just put the parentheses S. So, because again, there are separate statements, and the jury should be instructed, each statement has to be considered individuals.
You see it, it was fine.
Okay. The only other matter was the reasonable doubt instruction, and we talked about, and I had initially indicated that I was going to instruct with the amended instruction June 12th, which was then amended again, and what I am going to do actually is instruct the jury on reasonable doubt as the instruction existed in the standard prior to June 12th. At the start of the case, when the jury was sworn, which was June 5th, I think. No, I didn't swear the jury until the 8th, but everyone was in agreement with that. I think I didn't have any objections to that.
So, that's right, we had asked for the original instruction supplemented by the U.S. Court of Appeals for the 11th Circuit's language.
And in that regard, I am not including the additional language of the 11th Circuit Federal Standard instruction, but it's going to be the reasonable doubt Florida Standard Jury instructions pre-June 12th.
I think that covers everything.
I think we covered everything on the instructions. If you see anything in the packet, sometimes you look at things over and over and over again and you miss something. So fresh eyes, if you see something that is incorrect, would you please just make a note of it, and I'll make those corrections during the course of the morning. So, Renee, how are we doing with the jury?
I haven't done it yet.
Okay, can you go up and check them out, please? Because I think we're just about there, right?
Okay.
I just left my water bottle with my shoes in.
I can actually, please don't sit up. May I see the court reporter with the attorneys at the sidebar for a moment? Thank you. For your patience, and I'm also stalling because I'm waiting to hear from Renee whether the jurors have all arrived and are ready to be brought in. And they have not. So waiting for the jurors. And while we are waiting, I'm going to ask if anyone is in the courtroom who is an intern, not either a close friend or family member, I'm going to ask you please to vacate this courtroom. We have an overflow courtroom in 4-6. To please go over to 4-6 so that we can make space here, because I can't have anyone standing in the courtroom. So if you are not a close family friend or member of the family, you're going to need to please vacate your seats. Thank you so much. And if everyone else can please fill in the
Judge, while we're waiting for the jury, we did receive a paper copy of the proposed verdict form. And declines to give a special verdict for the different kinds of manslaughter. Just wanted to hear that.
That was the other request last week that we spoke about, that the defense had requested that the jury find, if they find either intentional act or culpable negligence, that they would have to find one or the other beyond a reasonable doubt unanimously, and do that in the form of a special verdict. And I declined to give a special verdict form, but that was also preserved by the defense. Thank you. Okay, now I have the jurors. So they are coming down. Very good.
Judge, we'll take a break after the state summation, so I can organize things.
Judge, I'm ready. You ready?
I am.
All right.
I have a couple of days off, and I have important questions of you. Have any of you engaged in any independent investigation or research